Let's talk about what are the key standards and guiding principles that states should have in mind when regulating freedom of assembly. Peaceful assembly guiding principles should be contained in all aspects of the drafting, interpretation, and application of legislation relating to this right. First, we will discuss the presumption in favor of holding assemblies. As a fundamental right, freedom of peaceful assembly should, as far as possible, be enjoyed without regulation. Anything not expressly forbidden in law should be presumed to be permitted, and those wishing to assemble should not be required to obtain a prior permission to do so. A presumption in favor of the peaceful assembly should be clearly and explicitly established in law, either through a constitutional guarantee or in the relevant legislation. Second, the sight and sound principle. This principle means that assembly participants should be able to effectively convey their message to the target audience, namely within their sight and sound. This further means that the state should always seek to facilitate and protect public assemblies at the organizer's preferred location and should be also able to ensure that efforts to disseminate information to publicize forthcoming assemblies are not impeded in any way. Freedom of peaceful assembly also includes the right to protection against violent counter-demonstrations. Even in cases when counter-demonstrations may give rise to public safety and security considerations, the authorities should generally seek to facilitate the holding of an assembly and related counter-demonstrations within sight and sound of one another. The state has to ensure adequate policing resources to facilitate both assemblies. The next principles to bear in mind are those of legality, proportionality, and non-discrimination. Restrictions on assembly must only be imposed where there are compelling arguments to do so. Any limitations imposed on assemblies, in law or in practice, should not be based on grounds other than those permissible in accordance with international law and must be necessary, proportionate, and non-discriminatory. These principles will be elaborated in more details when we tackle restrictions. Finally, let's talk about the principle of notification, good administration, and legal remedies. As stated before, right to peaceful assembly should be practiced with minimum regulations. However, although not necessary under international human rights law, a requirement for prior notification of assemblies can enable the state to better ensure the peaceful nature of an assembly and to put in place arrangements to facilitate the event or to protect public order, public safety, and the rights and freedoms of others. Nevertheless, notification requirements should never be applied as a de facto authorization procedure, and assembly organizers should not be required to obtain a permit to organize their gathering. In addition, the procedure for notifying public authorities on peaceful assemblies should not be burdensome or overly bureaucratic, and national legislation should also recognize the possibility to hold spontaneous assemblies, clearly exempting them from prior notification requirements. It is important to note that the process to notify assemblies to the authorities should be both transparent and should allow for accountability. Transparency in the context of regulating freedom of peaceful assembly means that the public should clearly understand which body is responsible for taking decisions about the regulation of peaceful assemblies. The public should also therefore have access to information about the procedures and operation of the relevant regulatory authority. This also means that any restrictions placed on an assembly, which will be elaborated in a moment, should be communicated promptly and in writing to the assembly organizers. This should include an explanation of the reason behind the restriction. The restrictions must be communicated in a timely manner to give enough time to assembly organizers to appeal the decision if needs be. On top of this, those seeking to exercise their right to freedom of peaceful assembly should have access to a prompt and effective legal remedy against any decisions of the regulatory authority disproportionately, arbitrarily, or illegally restricting or prohibiting an assembly. This also requires the court decisions on an appeal or challenge of a regulatory decision to be issued in a timely manner, so that it can be resolved before the assembly is planned to take place. Restrictions on the right to freedom of peaceful assembly were mentioned several times. Even though restrictions on this right can be imposed in some circumstances, this can only be done under very strict conditions. In fact, widely defined restrictions on this right can lead to abuse of power and blanket bans. Any restriction on the enjoyment of the right to freedom of peaceful assembly, therefore, needs to respect the following principles. First, restrictions should be imposed in accordance with the law, and such laws should be foreseeable, accessible, precise, and in line with the international human rights standards. Second, restrictions should pursue a legitimate aim, including national security, public safety, protecting the rights and freedoms of others, prevention of disorder and crime, as well as protecting health and morals, which we will further elaborate on. Thirdly, restrictions need to be necessary in a democratic society, which means that there must be a so-called pressing social need calling for such restriction. 4. Restrictions must also be proportionate, meaning that only the least intrusive restriction must be used to achieve the legitimate aim identified. The principle of proportionality requires that authorities do not routinely impose restrictions that would fundamentally alter the character of an event, such as reallocating assemblies to less central areas of the city. And finally, non-discriminatory, which entails that states should facilitate all assemblies regardless of who is organizing it and what the messages are. The term restrictions must be interpreted to include measures taken before, during, and after assemblies. As mentioned, any restriction should pursue a legitimate aim. Legitimate grounds for restriction are prescribed in various international and regional human rights instruments and should not be supplemented by additional grounds in domestic legislation. We will now examine each of the legitimate grounds prescribed in the Article 21 of International Covenant on Civil and Political Rights. Let's start with public order. Even though the term public order is broad, it should not be used to justify any prohibition or dispersal of peaceful assemblies. As mentioned before, the mere hypothetical risk of public disorder or the presence of a hostile audience are not legitimate grounds for prohibiting a peaceful assembly. Further on, when we think of public safety, we often identify it with the public order. Public safety concerns could relate to, for example, assemblies which are held during the night, or when vehicles on the move are part of an assembly. In such cases, additional precautionary measures should be preferred over restrictions. For example, the speed of the vehicles can be limited to a walking speed, so it does not pose a risk to pedestrians participating in the assembly, and similar. As we saw during the COVID-19 pandemic, in exceptional cases, restrictions on assemblies may be justified on public health grounds. For example, where any type of gatherings increase a risk for spreading an infectious disease, or where the health of participants in an assembly or health of others risks becoming seriously compromised due to the sanitary condition of an assembly. Restrictions might, for instance, be justified on occasions where the health of participants becomes seriously compromised during the assembly itself. Nevertheless, such reasoning should not be preemptive and should be dealt with on a case-by-case basis. Moreover, these instances are rare, and public health emergency, such as COVID-19 pandemic, must not be used as a pretext to infringe and impose undue restrictions on the right of individuals to peacefully assemble. One of the most debated grounds for restriction on freedom of peaceful assembly is the protection of morals. It is important to emphasize that both the International Covenant on Civil and Political Rights and the European Convention on Human Rights are living instruments which are attuned to diverse and changing moral values. Therefore, restrictions on such grounds need to be proportional and need to undergo testing against an objective standard of whether they meet a pressing social need. Relying on such ground can too easily lead to regulation of the content of an assembly and in turn lead to discriminatory treatment. For these reasons, the protection of moral should not be regarded as a sole basis for imposing restrictions on peaceful assemblies. If a restriction is imposed on the grounds of protection of the rights and freedoms of others, the regulatory authority should justify validity of these claims and elaborate on how the assembly in question might infringe these rights. It further needs to justify the necessity of the restrictions, and finally, it should elaborate on why less intrusive measures could not be used. Occasionally, state invokes national security as a ground for restricting an assembly. Interpretation of the term national security in relation to freedom of assembly is often too wide. A decision to restrict an assembly based on national security should be based on so-called Syracuse principles of the limitation and derogation of provisions in the International Covenant of Civil and Political Rights. These provisions require that such restrictions need to be justifiable and aim at protecting the existence of a nation, its territorial integrity, or its political independence. However, these principles cannot be invoked if the threat is local or relatively isolated, and it cannot be used to impose vague or arbitrary limitations. Moreover, states cannot invoke national security to silence opposition or to repress its population. I will now outline the different kinds of restrictions that can be imposed on the right to freedom of peaceful assembly. The first category refers to restrictions on time, place, or manner of an assembly. The organizers have a right to choose location, form, and scope of an assembly. Therefore, restrictions should not prevent assembly access to the target audience, be used to undermine the message of an assembly, or be used to dissuade the exercise of the right to peaceful assembly. Moreover, when imposing restrictions on time, place, and manner of assemblies, relevant authorities should identify suitable alternatives, the sight and sound principle must be respected, and the rights of others should be balanced to accommodate the needs of all. Let's move on to the content-based restrictions. When it comes to content-based restrictions, we should emphasize that the assemblies are held for a common expressive purpose, and restrictions on assemblies should therefore, in principle, not be based on the content of the message that assemblies seek to communicate. Content-based restrictions should therefore meet a high threshold and should only be imposed in very limited circumstances. The content of an assembly can only be restricted in cases of advocacy on national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. Criticism of government policies or state official actions should never of itself constitute a sufficient ground for imposing restrictions on freedom of peaceful assembly. This also applies to assemblies expressing views that may offend, shock, or disturb the state or any sector of the population. Moreover, even where a content-based restriction is justified, authorities should take the least intrusive and restrictive measures to address the issue. The use of speech with prohibited content by participants in an assembly does not of itself necessarily justify the dispersal of the event, and law enforcement officials should take measures such as arrest only against the particular individuals involved, either during or after the event. Finally, we should have in mind that bans and prohibitions on assemblies are intrinsically disproportionate, as they fail to take into consideration the specific circumstances of an assembly. Such restrictions can only be justified if there is a real danger of disorder, which cannot be prevented by other less intrusive measures. In this video and the previous one, you have had the opportunity to learn about what is peaceful assembly, what are state obligations in relation to this right, what types of assemblies there are, what are key standards and guiding principles of the right to peaceful assembly, as well as when assemblies can be restricted. Some of the key messages to be taken from these lessons are that peaceful assemblies can sometimes be uncomfortable, intrusive, and provoking. And oppositely, that violent assemblies should be measured by the intention of the organizer to cause or incite hatred or violence. Moreover, peaceful assembly organizers have a right to choose when, where, and how will an assembly take place, and that they have the right to be within the sight and sound of those to whom they are directing their messages to. Finally, restrictions need to be based on law, which should be in line with international standards. They should be necessary and proportionate, and they should not discriminate anyone. In the end, it is important to reiterate that human rights, including freedom of peaceful assembly, are living norms, which are adapting to the emergence of new trends, challenges, and development. However, basic principles on which these norms function remain the same and should be respected by all.